CS Fondy AS. CS Fondy AS comprises three mutual funds that were previously managed by CS Fund, Inc., an investment company, namely the CS Capital Gains Fund, the CS Energetics Fund, and the CS Regular Dividend Fund. Since 1998, the funds have been managed by AKRO Investment Company, Inc., under the names AKRO Progressive Companies Fund, AKRO Global Equities Fund, and AKRO Balanced Fund. CS Funds Management. Until February 1997, CS Funds were managed by the CS Fund, Inc. After the receivership of Agribank in September 1996, the group decided to urgently sell off all their assets and leave the market. In the context, the owners of the CS Fund, Inc. decided to sell the company as well. This occurred in February 1997 when the CS Fund, Inc. was sold to a Cyprus-based company, Austell Enterprises Limited. Two changes of owners followed. Austell sold SC Fund, Inc. to a Czech company, Crassus Limited, who later sold it to a Russian company, Cosmos. The new management of CS Fund, Inc., appointed by the Russian owner, then stripped CS Funds of its assets. Subsequently, the management of CS Funds was transferred to AKRO Investment Company by decision of the Ministry of Finance, which manages it up to now. CS Funds asset stripping. CS Funds were stripped of their assets shortly after the CS Fund, Inc. came into the possession of Russian company Cosmos. CS Funds were taken over in a state where the majority of their assets were in bank accounts of the individual CS Funds in the form of cash due to the anticipated opening of the fund and expectations of equity markets decline. The board of directors, shareholders, and fund management learned about the changing of the owner on March 3, 1997, when Prague notary Robert Hochman certified Moscow's Cosmos Limited as the new owner of CS Funds, represented by Nikolai Trofimov. Company representatives of Cosmos Limited had the same notary register three Czech citizens as the new statutory representative of the CS Funds. One of them, at that time 21 years old, unemployed young man Vaclav Franta from Krastava near Liberec, got the right to sign a power of attorney to carry out transactions of the company. Later that day he took full advantage of it. He came to a Pilsen bank, where the money of the funds was deposited, and demonstrated his newly acquired power of attorney from representatives of Cosmos Limited and instructed to transfer 1.23 billion Cs, which were the entire assets of CS Funds, on behalf of the British Sworldlin Limited to purchase virtually worthless. The money traveled through the brokerage company Humana. The trade was mediated by Humana brokers Joseph Matulek and Vladislav Nad to Prague Bank Gyrocredit. From there they were supposed to be transferred abroad. Gyrocredit considered the operation to be so suspicious that they asked for an investigation by the Financial Analytical Department of the Ministry of Finance of FAUMF, which alone had the right to suspend the transfers. However, the director of FAUMF, Jerry Kudlik, allowed the transfer of the money abroad on March 11, 1997, after being visited by two representatives of the company Sworldlin. 12. Thus, on March 12, 1997, virtually all of the property of CS Funds definitely disappeared in accounts in Switzerland, Liechtenstein, Gibraltar, and USA. Investigation and its results. The shareholders of CS Funds were not content with the loss of their money and made a series of compensation claims. In January 2001, a judge of the municipal court in Prague, Hanna Hubakova, adjudged sentences ranging from 5 to 10 years over the four men involved in the billions being stolen from the CS Funds. However, in September 2003, a judge of the High Court in Prague, Pavel Zelenka, returned the case to the municipal court with the requirement of evidence completion. His main complaint was that the municipal court used as evidence Russian interrogation of Trofimov, which the advocates of the defendants were not allowed to participate in. In March 2002, the clients of CS Funds won the dispute with the Pilsen Bank, which, as a depository for the funds, was not supposed to carry out the suspicious transaction. Since mid-1999, the executives of Crassus Company, Peter Muller and Jaromir Florian, were prosecuted because by a few financial transactions they created worthless shares of Poultry Prazavis AS, which were sold to Cosmos Limited for more than $1 billion CZK at the end of February 2003, an important verdict in the case. Judge of the District Court for Prague Forturnova decided that the Treasury must compensate one of the shareholders of the CS funds, Zdeněk Rypka from Hrad Králov, 88 CZK plus the cost of the legal proceedings. The verdict meant good news primarily for the other CS funds shareholders. It was in fact the first ever compensation controversy which the Treasury lost. In October 2007, the police suggested to the prosecutors that Pavel Tykak was allowed a retrial in early 2013. This was suggested by the Chief Public Prosecutor's Office in Prague in 2012 based on the allegations of businessman František Busek, formerly Chobota, and his companions Klaus Schmilpfennig and Oskar Gerlach that Tykak's funds stripping of assets. They submitted the minutes of an alleged meeting in Kufstein, Austria, where they were supposed to be negotiating the division of the stolen money. The argument of these people was extremely challenged when the presented minutes of the alleged meeting proved to be clearly forged. According to forensic experts, the creator of the minutes, which were supposed to be created in 1997, used Calibri font which was created a few years later, designed in 2003 and expanded for everyday use in 2007, which clearly indicates the very antedating of the record. They themselves refused to testify either out of fear of being prosecuted, or as witnesses they testified to something else, when according to the evidence the CS funds money ended up in the accounts of persons other than Pavel Tykak. Tykak himself stated from the beginning that already in 2011 Busek blackmailed him that if he did not pay 500 mil CZK, he would produce evidence against him and accuse him of CS funds asset stripping. The statement was not proven to be true yet, but the fact is that the renewed prosecution Tykak was accompanied by a number of other substandard conditions and steps which have become the subject of discussion in professional circles, and the prosecutor's office eventually stopped the prosecuting of Tykak in December 2015 after nearly 3 years of renewed investigation. Another person talked about in connection with CS funds asset stripping at least since 2004, but never accused of it, is the controversial financier Petr Sisak. His former girlfriend Lucy Lund, formerly Vaklavakova, and also the sentenced Joseph Matulek pointed out Sisak and people surrounding him. Demonstrably, the people from his surroundings were connected with the case. Sisak's father-in-law, Jaromir Florian, at the time the executive director and shareholder of Crassus Limited, which sold the CS funds to the Russian Cosmos, or Sisak's longtime collaborator Peter Muller, along with Jaromir Florian, he was the managing director and shareholder of Crassus. The convicted in the case Matulek described Sisak with Florian and Vasil Mohorito, Florian's half-brother and former chairman of SSM, as the main masterminds behind the CS funds asset stripping. Finally, the already mentioned Busek, Schmilpfennig and Gerlach, or their collaborator Gunnar Kuhn, the former CEO of Swirlglin, via which the stolen money traveled abroad, were never accused in this case, even though they admitted the participation in the fraud. Compensation. The forced administrator of CS funds, with the help of hired lawyers and detective agencies, managed to track down a significant part of the stolen money and get about 200 mil CZK back. AKRO received another 650 mil for the funds from the sale of compensation claims against the Pilsen Bank. In 2012, AKRO recovered an additional amount of almost 2.1 billion CZK in compensation for damage from the state. The verdict was subsequently overturned by the Supreme Court, but since in the meantime the state had already paid the compensation amount to AKRO and AKRO refused to return the amount paid, the state currently seeks return of the money by legal actions arising from unjust enrichment. In case the lawsuit ended in favor of AKRO, and AKRO would not be required to return the money, The acquired amount for the damage compensation, of which a considerable part consists of high interest rates, would reach 2.9 billion CZK. Thus, it would significantly exceed the original amount of the caused damage. The whole affair can paradoxically end very favorably for the shareholders of former CS funds. References